Good evening, everybody. Welcome to this public lecture organized by the Center for Comparative and Public Law at the University of Hong Kong. I'm Kelly Loper, an associate professor in the Faculty of Law and also director of the center. I'm very pleased to welcome back a very good friend of the faculty's, Judge and Professor, I'm not quite sure which to call you, but Judge and Professor Lech Garlicki, who we've been lucky enough to have visit our faculty on a number of occasions over the last several years to teach courses on international human rights. This semester, a new course on EU law, which has proved to be quite popular. And he's also taught courses on the European Convention on Human Rights. He was a judge for 10 years on the European Court of Human Rights. Prior to that, he served as a judge of the Constitutional Court of Poland for 8 years. And he's also quite a prolific scholar with 300 publications to his name. And he has also been a visiting scholar, a professor at the University of Warsaw, and a visiting scholar at institutions all over the world. So he's speaking to us tonight about a very timely topic, I think timely globally. It's a hot topic, and also quite timely locally, since there are several cases that are currently working their way through the courts in Hong Kong related to sexual orientation and same-sex couple rights. So without further ado, I would like to please join me in welcoming Professor Lech Garlicki.
Thank you. Thank you, Kelly. Well, it's a great pleasure and a great honor to be here. It's not my first time, as Professor Loper already managed to remind me. Actually, it's the fifth time I'm teaching a course or some courses at this law school, and I must say I'm probably among those persons or those expatriates who already got some Hong Kong virus. Okay, I already got and won against my flu virus during this visit, but more friendly and nice virus, namely that it is always very nice time for me to be in Hong Kong, and this is something we really like. With my wife, we already regard it as one of the most pleasant parts of a year. Well, with 24 Celsius here and about 3 or 4 Celsius in Europe or in the US, of course the choice is not particularly difficult. Now, what I'm going to do tonight is to talk about sexual orientation and fundamental rights from the European perspective, mostly from a perspective of judicial decisions dealing with the problem, and mostly in the perspective of same-sex couples and their legal recognition. Geographically, it's about Europe, of course, with some excursions to other legal systems whenever necessary. Let me start with something all lawyers say when they do not want exactly what should be the conclusion of their presentation, namely that the problem is complex and complicated. And this is true because after having read several decisions of several jurisdictions, one may sometimes have an impression that many courts did its best not to tell too much or to avoid taking decisions which would more or less clarify the problem from the very beginning to the to the very end. But let me start with three general observations about the context. First, of course, there is quite clear historical or cultural tension between history and traditional approaches to sexual orientation and in particular same-sex couples and the modern approach. The position that sexual orientation is either straight or represents some kind of deviation, which rather deserves attention of medics and at best police authorities. This perception is not so extinct and not so distant from our present times. I think I lived at least for 40 years in a world where sexual orientation was very clearly built on this black and white premises, and we know that even in modern times sexual orientation may well end in physical elimination of a person, whether it was the German constitutional camp, concentration camp, or whether it was a Soviet gulag. Even the shock of the Second World War and all the atrocities of the Second World War was not enough to depart from this traditional position of condemnation and discrimination. This is very important because most of the instruments, constitutional instruments in Europe or international human rights instruments were drafted immediately after the Second World War. And whereas in this instrument there was a lot of room for understanding and protection of numerous human rights, there was still no room for problems of sexual orientations. These problems were somehow left as still traditionally accepted as not deserving a clear constitutional or international law position. So the starting point was not particularly attractive, and this was only from late 1960s. Probably the sexual revolution in the US was the triggering moment where the problem of sexual orientation began to be more closely connected with problems of fundamental rights, generally speaking, in Europe as well as in the US. They were these three consecutive or partly overlapping periods. First, toleration, in particularly by decriminalization of homosexual practices, then inclusion or partial inclusion of different sexual orientations into general stream of social and cultural life. This found its legal expression in different applications of prohibition of discrimination to discrimination or classification based on sexual orientation. This approach, which is still quite valid and quite vivid today, had, however, one very important characteristic. This was a sectoral approach. Namely, there were specific problems. The specific problems were addressed either by the legislature or by the court, and usually were solved under this heading: no more discrimination based solely on sexual orientation of a person, but still they were only sectoral interventions without changing the whole pattern that sexual orientation or same-sex couples do not deserve a full constitutional recognition. And this is only the last stage of this quite dynamic process where legislatures and courts began slowly realize that it is not enough to decriminalize. It's not longer enough not to discriminate in one or another occasion. What is necessary is to recognize or to ensure a full legal recognition for same-sex couples as protected species, as legally recognized nucleus of family life. This stage is still very far from being implemented in the global level. In some regions, some continents, it's quite advanced. In some other regions and some other continents, it's not very much advanced or not advanced at all. In Europe, as we will see, it is advanced, but not everywhere. It's very advanced now in Western Europe. It's not very advanced in some, let's say, post-communist regions of Europe. So this is history, the historical development. Then a second general remark is that there are still no universally accepted, there is still no universally accepted answer as to the legal nature of the emerging system of recognition. Is it just a generosity of the legislator? That the parliaments simply eliminate some problems which existed before, not, however, being constitutionally obliged to do so, or do we have an emerging fundamental right or human right, namely, do we have a higher right which must be respected and observed by the parliament? So is it just a present, a gift from the politicians assembled in parliaments, which they may give or may not give, may revoke perhaps, or it is just a higher law, like classic freedoms, freedom of expression, freedom of religion, whatever freedom, that exist above legislative discretion and which must not be neglected or must not be refused by the legislature. Here we do not know. There is a clear trend, of course, particularly in the doctrine, that there is a fundamental right, or that are fundamental rights involved in the process. And of course, once we accept that there is a fundamental right, it means not only that the role of the parliaments or of the political branches of government is more limited, or their discretion is more limited, it also means that the courts must be involved in the process, and the courts must be able to exercise their general power to review political decisions or ordinary legislation of parliaments. But this is still one of the question marks. So exactly, do we have fundamental rights here? What kind of fundamental rights? What is the textual basis for these rights? This is something I will address in a moment. And finally, when we are talking about Europe, we also should remember that the structure of, let's say, higher law, constitutional or supranational law in Europe is quite complicated. There is this multicentric system of different instruments, national constitutions, the European Convention on Human Rights, the EU law with the EU Charter, each providing some catalogue of rights, each addressing more or less the same rights or similar problems, each having their own supreme or highest courts deciding the cases, but the result is that there is a pluralism of different systems, not always necessarily coordinated with each others, which makes the life of European lawyers quite interesting, because sometimes it's very difficult to tell where shall I look, the Constitution, the European Convention, the EU law, to find the answer which should be binding. So my first question is, if we have a look into the situation in Europe, do we have a fundamental right concerning recognition of legal couples, and what kind of fundamental right is it? Let's start from a very brief statistical overview. Europe is quite advanced in the process of legal recognition. This legal recognition is mostly based on legislative decisions. Already Denmark in 1989 adopted legislation on civil partnerships. 12 years later, 2001, the Netherlands was the first country in the world which extended the institution of marriage to same-sex couples. And this concept of legislative recognition, either by establishing a separate institution, civil partnership, whatever it could be called, or by extending the institution of existing institution of marriage, continues today. In the beginning of 2019, same-sex marriage is allowed in 16 countries of Europe. 12 further countries provide for different forms of civil partnerships, which makes 28 out of 48 countries of Europe. So this is more, but still this is not a situation where a uniform approach to legal recognition can be regarded as already confirmed. So this makes a difference in comparison to some other areas of the world. There are two trends. One in Europe is that as far as the general trend is the legislative way. So practically in all European countries, the development of or sequence of events is that first we have decision of the parliament introducing some kind of legal recognition. And then courts, if intervene or if enters into the play, do it only after. It's not typical for Europe that courts are the first telling the legislature you must do something because this is absolutely required by the higher law. In other words, also the courts are quite willing and ready to extend protection offered by some general constitutional clauses to some specific aspects of sexual orientation or situations of persons of different sexual orientations. This is mostly based or done upon some extensive interpretation of principle of equality or prohibition of discrimination, but also some other general constitutional clauses. Yes, this is the courts are ready to do. This is what the courts are doing in most European countries, even not only in the West, but this is, let's say, a creative interpretation of existing general constitutional clauses against, first of all, the clauses connected to equality and non-discrimination. On the other hand, however, the courts are more careful in discovering new fundamental rights or in departing from some written norms of constitutions or international law instruments as regards general recognition that there is a fundamental right to recognition of same-sex couples. Here, the courts are rather careful. I come back to this in a moment. Some observations about supranational standards. The European Convention on Human Rights. The European Convention on Human Rights has been drafted in the end of 1940s. Probably none of the authors of founding fathers of the convention had ever been able to imagine that sexual orientation problems would occupy so prominent part in the case law of the court 50 or 60 years later. So we better forget about the original intent, because the original intent was not particularly friendly to the problem. Nevertheless, the European Court was entering the scene in a quite attractive way. Already in 1981, the court decided that a penalization of homosexual intercourse is in violation of the convention. This is 1981. If we compare it with the case law of the US Supreme Court, which still in 1986, in a clear language, declared the opposite position as far as constitutionality of criminal punishment was concerned, this was clearly some kind of an achievement, and this was clearly a decision which included sexual orientation, at least as far as criminal law problems were concerned, into the world of fundamental rights. And the same was true for further decisions of the court since mid-1990s, namely slow application of prohibition of discrimination to same-sex problems or the problems of sexual orientation, even if the text of the convention was, of course, completely silent to this. The court developed the concept that sexual orientation as such is a suspect criterion or prohibited criterion of classification. So wherever there is a classification based exclusively or predominantly on sexual orientation, there is a problem under the convention. But this was the sectoral protection. When it came to the question whether there is a convention right to general legal recognition, the European Court was more careful. The first decision came only in 2010 in Schalk and Kopf versus Austria case. Then the court told two very important things. First, it decided same-sex couples or the existence of same-sex couples is a part of the family life, and it must be protected like any type of family life under the convention, strong protection. Then the court sent a signal that it probably means that the convention requires some kind of legal recognition of same-sex couples. But as in the meantime, the Austrian legislation introduced the civil partnership as a legislative solution, the Strasbourg court held, well, it's not necessary for us to decide on this problem, it is just a signal. But at the same time, the court also held that the convention does not grant a right to marry to same-sex couples. The court read the convention. Article 12 of the convention says about that men and women have a right to marry. Said, okay, I'm sorry, this is the language of the convention. No living instrument or dynamic interpretation allows us to abandon the language. So this was the point where the court stopped in their creative interpretation of the convention. Then in the next case, 3 years later, a case against Greece. The court was confronted with a situation. Greece adopted new law on civil partnerships, but allowed civil partnerships only to heterosexual couples. This was easy for the court. Classification based solely on sexual orientation. Violation of prohibition of discrimination. The court very wisely avoided the question, is there a fundamental right? We do not know. This is not necessary. Where is the problem? The problem is that if the national legislature adopted new solution concerning civil partnerships, it must not be done in discriminating same-sex couples. Again, protective for individual rights, the general message not fully clear. And this was only in 2015 in an Italian case, Oliari, where the court finally said, yes, the lack of legal recognition of same-sex couples doesn't matter whether it is marriage or civil partnership or any other type of full recognition, is in violation of the convention. So, in a sense, we had fundamental rights. But at the same time, the court was very careful and focused its argumentation mostly on the Italian situation, saying, well, the situation in Italy is that there is a very wide social approval for same-sex couples, that in most parts of Italy same-sex couples openly live together. There is some case law of the Italian courts indicated that recognition is required under the Constitution. So in this situation, yes, it has to be done. What was not answered by the court, however, was the question, what about other countries? So again, is this a convention right, which establishes a new standard, universally applicable to all convention countries, or it is just the conclusion resulting from a particular situation of Italy? And this is something we still do not know. So, as far as the European Court of Human Rights is concerned, well, it did, of course, a very good job, because it did elaborate a convention basis for legal recognition of same-sex couples. It declined, however, to recognize that this recognition must extend to the right to marry. The court said this is up to the legislature, up to the national legislature. And finally, the court left unanswered the question how universal this new standard is, and to what extent this standard must apply to these countries which do not like the idea of legal recognition of same-sex couples since at least 5 years. There are several cases from Russia pending before the European Court, and it doesn't seem that the European Court would be willing to decide these cases with a lot of promptness, just because the position of Russia and Russian society is quite different than the position of Italian courts and the Italian society. What about the European Union? Well, the problem with the European Union is that regulation of family matters does not belong to the competencies of the Union. So there is a very delicate problem to what extent the institutions of the EU and the EU Court of Justice can enter into these problems. In the case law of the on the Court of Justice of the European Union, this is clearly confirmed. We do not have competence to decide what kind of family law or what kind of, let's say, collective family institutions should be adopted in the member states. What we can do, however, is to intervene wherever the EU law allows us to do. And again, there is a developed case law concerning prohibition of discrimination, and this is clear that, again, classifications based on sexual orientations are not acceptable. And there is also quite interesting application of this case law to another convention, to another right guaranteed on EU level, namely right to or freedom to reside in any member state's country wherever there is a problem of a validly concluded marriage in a country which allows for it. And now, whether the partners should be allowed to reside in other countries which do not allow such marriage, then the court is quite clear, saying this is regulated or this is protected under the EU law. But again, we must not have too wide expectations as far as ECJ is concerned due to this general problem of competencies. On the domestic level, this interplay between courts and parliaments is quite interesting. Comparing five, practically leading constitutional jurisdictions in continental Europe, again, the general picture is a picture of deference, judicial deference to decisions of political branches of government, and judicial deference which is expressed, one, by timing of the judicial decisions, and two, by, generally speaking, a high degree of identification of court's decisions, or let's say confirmatory approach of court's decision to existing legislative solutions. Still, the level of this confirmatory approach is not necessarily the same. And again, what I'm talking about are the most developed constitutional jurisdictions on the continent. On the one, let's say, side of this spectrum is France and Portugal. In France and Portugal, we have a very interesting sequence in the end of 2000s. I think in 2009, 2010, both Constitutional Court of Portugal and the French Constitutional Council were invited to decide on the challenges to the traditional solution of civil code, of family code. Marriage is an union of men and women. And the courts had to answer the question, maybe this is unconstitutional, limitation of marriage to a heterosexual nature of marriage. Both courts decided this is something which is within the question of the legislature. Yes, it's true, constitutions do not require heterosexual nature of marriage, but also do not require extension of marriage or any other type of legal recognition elsewhere. In France, it was easy because there already been legislation on civil partnerships in this time, so this was only the question of marriage. But generally speaking, the Constitutional Court said, no, this is not the problem which we have decided because the discretion of the legislature is not apparently limited by any generally existing fundamental rights. Then both countries introduced same-sex marriage. Then the new legislation was challenged before the courts, and again the court said, well, this is not forbidden. If the legislature likes to do it, this is within the legislative discretion. We need not to intervene. This is constitutional now to have a same-sex marriage and to have reforms of the legislation. So these two countries showed, let's say, the full or the highest amount of legislative deference. Then we have Spain, and in Spain the situation was different because the same-sex marriage was introduced by the legislation of 2005. It was challenged before the Constitutional Court. The Constitutional Court decided only in 2012. What was interesting in Spain was that the Spanish Constitution when addressing marriage, gave more or less the same definition of marriage as the European Convention. Men and women have a right, etc., etc. So the problem was for the court how to go around this definition. The court said, we do not think that the original intent is decisive. And by the way, the original intent was rather to ensure equality of men and women in marriage than to petrify heterosexual nature of marriage. This was demonstrated in the constitutional debate in 1978. But in any way, it's a long time ago. Nowadays, we are of the opinion that this is within the discretion of the legislature. What the legislature is not allowed to do is to deprive heterosexual couples of a possibility to marry. But at the same time, this is within the discretion of the legislature to include or not to include homosexual couples or same-sex couples into the institution of marriage. There is nothing unconstitutional in it. So, in a sense, this was also a decision of deference to legislative solution, but the court was probably more talkative as far as the fundamental rights arguments were concerned. It developed a concept of dynamic, or rather it applied the concept of dynamic interpretation of the Constitution, of the text of the Constitution to the problem. And by the way, it also mentioned the Canadian concept of Constitution as a living tree, not mentioned the concept of the Strasbourg Court of living instrument, which was also quite interesting, let's say, from a protocol point of view. So it seems that the Spanish court not only deferred to the legislative solution, but also sent a clear signal that there is a fundamental right dimension of the right to marry. It's not necessary to enter into it because the legislative regulation is sufficient, is constitutional, but such a dimension may exist. Then, let's say, the next stage was of this deference or limited deference was Germany. But the strongest court in the continent, one of the strongest courts in the world. Germany adopted a civil partnership law relatively early, so the German Constitutional Court decided the case already in 2002, so quite early whether civil partnership law is constitutional. And then this Constitutional Court had a problem because the German Constitution does not contain any definition of marriage or any heterosexual definition of marriage, but such definition of marriage was adopted in the case law of the Constitutional Court. So the court said, even if civil partnership is in fact giving almost same rights and obligations to married couples and to civil partnership couples, it doesn't matter. What matters is that the Constitution requires that marriage, namely traditional marriage, is under a particular constitutional protection. So as long as same-sex couples are not given more than traditional marriage, and as long as it is not prohibited to heterosexual couples to marry, there is no constitutional problem, even if marriage as such should be rather reserved for same-sex, for heterosexual couples. Good. This was 2002, and of course this allowed the Civil Partnership Act to continue as confirmed in its constitutionality. But there was a very clear signal, maybe even a warning, then in 2002 to the legislature, but if you want to give them the right to marry, then this is not so clear constitutionally. Well, the German legislature did it in 2017. So the problem is now whether it is constitutional or not. As of now, the Constitutional Court avoided to hear any cases. Sooner or later, it will. And once it will, it would have probably to say whether the previous interpretation of the definition of marriage as heterosexual marriage is still valid or is no longer valid. Most probably it will be the former, but it will be interesting how the German court will address the problem. So again, deference, strong warning, don't do certain things. Now, after some years, we see that this warning was probably not the best idea because it may create some problems. And finally, to finish this, Italy. In Italy, there was no legal recognition, neither partnership, no marriage, mostly due to cultural reasons, or mostly due to the political positions of the legislatures. In 2010, the Constitutional Court of Italy decided a case where it said, as a matter of fact, it's unconstitutional. There is a right of same-sex couples to some kind of legal recognition. This right results from constitutional provisions like prohibition of discrimination, say human dignity, etc. However, this is rather for the legislature to decide how to remove this unconstitutionality, so we are not going to declare that relevant provisions of the Civil Code are unconstitutional, but as a matter of fact, we are expressing our opinion, are sending a signal that it is an unconstitutional situation we do have. It was 2010, it was repeated once or twice later. This was one of the main bases for the European Court of Human Rights in 2015 to say this is a violation of the Convention. Even your own constitutional court indicated that there is something wrong with this situation, and in 2016 the Parliament adopted a new act on civil partnerships, not free of some problems, but there is no time to discuss it. So, this brief review of Constitutional Court decisions shows us that again, once the courts were not ready to take law in their own hands, apparently they rather wanted the legislatures to deal with the problem. But on the other hand, in most countries, I'm talking about, it was not absolutely necessary because there were usually some legislative actions either completed or well advanced. So this deference of courts or this reluctance of courts to decide questions for themselves did not have detrimental situation on real protection of individual rights. Where was the problem, however, was the problem of, again, fundamental right basis for recognition. Is there a right, or it is just because the parliaments are nice and want to help same-sex couples? There are some hints in the case law of the constitutional courts, practically all these courts, that there are some elements of fundamental rights in it, but as the existing legislation gives a very wide recognition, and on the so there is no reason for the court to invalidate it. If it is no reason to invalidate it, there is no reason to define what fundamental rights could enter into play. In those countries where the legislatures do not want to ask, there are no cases before the courts. And here probably is one of the problems with the European Court of Human Rights. Maybe it could have been a little bit more active. So this is the picture of Europe, at least of those countries of Europe where constitutional courts were involved in the process. One concluding remark to this is that this is not necessarily the picture typical for other developed jurisdictions, constitutional jurisdictions. We have several countries in which the courts played decisive or at least formidable role in arriving to the full legal recognition of same-sex couples. As we know, the first was probably the Supreme Court of Canada. Okay, this was still within this concept of deference to legislative proposals, because this was the advisory opinion, confirming the constitutionality of what already been proposed in the parliament. But then we had the judgment 2005 of the South African Constitutional Court, probably the first judgment of an important constitutional jurisdiction, simply declaring the existing system is unconstitutional. You have 2 years to do something about this. If not, this simply will no longer be regarded as a valid, as valid law. And then we had several other courts also developing some more independent or active approach. Of course, a climax were two judgments of the US Supreme Court, well, relatively late, 2013, 2015, Obergefell, but then the decision of the Constitutional Court of Columbia, 2016, Taiwan, 2017. So now we have a series of such decisions, which of course is much easier after these major courts have already taken a position. Whether it is always effective, it's not so clear. In Colombia, it's not so effective. In Taiwan, there are also problems. In the US, it's probably more effective than anywhere else. But the clear advantage is that all these decisions declaring unconstitutionality of the, let's say, traditional solutions at the same time had to define fundamental rights, which constitute basis for obligation to grant full legal recognition to same-sex couples. So from the constitutional point of view, or fundamental rights point of view, this is an approach which of course is much more clear and much more encouraging for other jurisdictions and other courts. By the way, also very recently the Inter-American Court of Human Rights declared that there must be some sufficiently complete legal recognition of same-sex couples in all countries members to the Inter-American Convention. Now, three brief examples on other problems. So let's assume that the problem of legal recognition somehow is being diluted. Problem number one is what about some indirect recognition of same-sex partnerships? And again, this is something which is visible today, even if the courts are not ready to intervene frontally, imposing some concept of fundamental rights and model of legal recognition generally on the legislature. The courts are still willing to intervene into these partial situations, and in particular, as far as movement between different countries and different jurisdictions is concerned, there are several decisions of the courts, again, a very recent decision of the ECJ, quite recent decision of the European Court of Human Rights, or rather series of decisions, more or less say, if there is a validly concluded partnership or marriage or whatever somewhere, then there is a convention right or there is an EU fundamental right that this also should be recognized in other countries member to the convention or member state of the EU. So even if these courts are not yet ready to accept generally existing fundamental right to, or universal fundamental right to recognition, once they can get hold of some exceptional situation, like freedom of movement, where other more specific fundamental rights are involved, they are willing to intervene. Another interesting area is the area of, let's say, inverse discrimination. Okay, the first concept of dealing with the problem was you, same-sex marriage, same-sex couples. You will have civil partnerships, and you, heterosexual, you will continue with marriage. So there is some kind of a division, but still we are not identical, but you will have full recognition. And it was accepted by most courts, at least at this time when it was created. Then, in many countries, the legislature decided, no, let's give the right to marry to both same-sex couples and different-sex couples. But in some countries, civil partnerships were not abolished. So, for example, in the UK and in Austria, there was a situation where inclusion of same-sex couples into a possibility to marry did not deprive them, continue to have a possibility to enter into a civil partnership. But this possibility did not exist for heterosexual couples. They only had a choice to marry or not to marry, and that's it. So there were cases brought by heterosexual couples saying, oh, now we are discriminated. They have two institutions, and we have only one. The European Court of Human Rights decided no case. This is margin of appreciation of the state. This is a different situation, which was probably not a very wise decision. This was decision in the Austrian case, because 2 months later, the Austrian Constitutional Court decided this is unconstitutional. This is a violation of prohibition of discrimination. So this cannot be like that. And the same decision, even earlier, was adopted by Supreme Court of the United Kingdom. So we have an interesting series of cases, let's say, going other direction, and we'll see whether it will continue, or whether it will be just a good joke, or whether it will be something more serious, and how legislatures would react to this. And finally, the last question or last set of problems is the collision of rights. Namely, legal position of same-sex couples has been recognized, meaning same-sex couples must be treated like all other couples, must not be discriminated. Now, if I have a business and I don't like homosexuals, or I believe, and this is my religious belief, so protected under all possibly fundamental rights, that homosexual contacts are sin. So if I accept homosexuals under my roof, or if I sell some commodities to homosexuals, in a sense I'm participating in sin, and my religion does not allow me to do it. So I need an exemption. And the problem was, should there be given an exemption to such a situation where a sincerely held religious belief prompt an owner of a business to exclude homosexuals or homosexual couple from access to a particular service or services. 3 cases deserve attention. The first was a case from the UK, Hull versus Bull, or Bull, I suppose, from mid-2000s. This was a hotel, and this a private hotel, and then the owner had policy that they allowed a double bed, or rather a big common bed, only to married couples. And as far as non-married couples, homosexuals or heterosexual couple, doesn't matter where concerned, they could get a room, but with two separate beds. And there was a same-sex couple already who had entered into civil partnership, which requested a room. They do it on internet, so they got it. When they arrived to place, they were told by the owner, I'm sorry, but apparently you are not married couple. So we cannot give you we cannot accommodate you. Everything was very nice, everyone was very polite, and that was the case. The answer for the Supreme Court was relatively easy because it was not only to be decided on the fundamental rights area, but also could be decided on the legislative area. There was an extensive anti-discrimination legislation in the UK, so this was clear that this private regulation constituted indirect discrimination, so discrimination which in a practical operation was disadvantaging same-sex couples in a particular manner. The problem was whether it was also a direct discrimination. The court, but by a small majority decided yes, it was also a direct discrimination. There was one argument of the court, however, which made the whole problem a little bit less clear. The court said, well, we do not need to decide whether there is some abstract fundamental right. What is sufficient for us to find both discriminations is to establish that this couple already have concluded civil partnership, meaning they have entered into a relationship recently recognized by the legislature. This is the will of the legislature. It should be respected. We should interpret the law in giving full force or full recognition to this legislative intent. So again, a little bit towards deference to legislative solutions, which of course was relatively easy. What was, however, also important, the court said something to the respect that, well, of course, religious exemption is important, but we cannot extend religious exemptions too far, because then it would provoke discriminatory situation in a very wide area. Now, the U.S. Of course, in the U.S. it could arise only once it was recognized that there is a right to marry or to enter into other types of partnership. Then there was in Colorado the so-called wedding cake case when the baker, a very good Christian, refused to sell a wedding cake to a homosexual clients. This was, and then the Supreme Court finally decided that it was unconstitutional to sanction the baker for refusal to sell. But at the same time, the Supreme Court was not extremely clear in their decisions. The court first had some paragraphs indicating that as a matter of fact, sexual orientation is a protected characteristic. Any discrimination is constitutionally problematic. So, as a matter of fact, the legislature is under an obligation to prohibit, to sanction, to protect same-sex couples in situations like that. But then they said, well, but in this situation, number one, it was in Colorado. In Colorado at this time, same-sex partnerships has not been legally recognized. This wedding was to celebrate a marriage validly concluded in Massachusetts. So maybe the baker was not entirely unreasonable, assuming that he would not only support something he believes is religiously unacceptable, but also something which was not acceptable under the laws of the Colorado. So who knows? Of course, an a contrario message was today, after Obergefell, where it is clear that there is a constitutional right to such marriage, this argument is no longer valid. So this was also a historical argument. And then they said, oh, and on top of that, the Colorado Commission, the Anti-Discrimination Commission, which decided the case, they were extremely hostile to the baker. So we have an impression that they did not offer a fair trial or the fair procedure to the baker. And then the court said, okay, Protection, sanction, enforcement of non-discrimination, yes, but not at the expense of procedural guarantees. So this particular situation or this particular sanction is unconstitutional because of the due process requirements, etc. So what is the general message? We do not know. Most probably the general message is that in the future, providing now that the constitutional situation is clear as far as the existence of fundamental right is concerned, at least since 2015. And providing there are no problems with due process, this is not possible to refuse. And again, the court said something, religious exemption, important, but this could apply, let's say, to a priest, but not necessarily to a baker. So there were some hints, but this was, I think, one of the last, or maybe even the last judgment written by Justice Kennedy. Apparently it was a compromise judgment of the court. Who knows? And finally, the last case decided 2 or 3 months after was the UK Asher's case. Similar cake case, only not wedding case, but a cake which was ordered, or was intended to be ordered for some kind of gathering supporting same-sex marriage in Northern Ireland. And this particular fellow asked the baker, okay, so prepare a cake, and then on this cake put 2 depictions of 2 men and its inscription, support gay marriage. And the baker said, no, I cannot do it because this is against my religion. If you want to buy any cake which is already ready, of course I will be glad to sell it to you, or whatever you want to do it with it, but I not put my hand into this dirty business of supporting the gay marriage because my religion does not allow me to do it. Again, the Supreme Court of the United Kingdom decided that this was not in violation of rights this was let's say that the rights of the prospective buyers were not violated by this refusal, so they gave justice to the baker. But they said, well, you have to distinguish between the message and the messenger. Had the baker refused the client because of the homosexual orientation of the client, then this would be an action based on sexual orientation, refusal of services, violation of existing laws. But this was the message. And the court said most probably the baker would have refused to have or to create such a cake independently on the sexual orientation of the customer. So the problem of sexual orientation or the problem of discrimination based on sexual orientation does not exist because it cannot be extended to sexual orientation of a message. It can only be addressed to sexual orientation of the client. And then the court said, okay, but maybe it was a discrimination based on political opinion. And the court said, well, not because even if generally speaking, this is forbidden to discriminate on political opinion, this would be a situation of so-called compelled speech. As the baker was invited to do this particular cake himself, not just give a cake to a person, and if clearly the message support gay marriage is a type of speech, then the baker would be compelled to participate in something being spoken or being expressed. He is not ready to accept. So again, a little bit twisted figure, but the conclusion, no the baker had a right to refuse. Again, we do not know too much, but those cases are interesting even if they may not be decisive for the very future of the problem. But as we can see, this is not only. But on the other hand, those two jurisdictions are very important jurisdictions. So the way how they are dealing with these cases is, of course, very instructive also for us. The conclusion is that, as I said in the beginning, the problem is complex and complicated. Now I can also add that the situation is dynamic, meaning that we do not know too much, but we have a lot of information how the situation has developed, which leaves a lot of options open. Still, I think the general impression is that there is a slowly emerging body of fundamental rights the courts are willing to apply to the problems of sexual orientation as such, and also to the problems of legal recognition, right to marry, etc., etc. But this is a process. This is still not finalized in many countries of the world, and particularly in Europe, it is rather left with some unanswered questions to the discretions of the legislatures. Thank you.
Thank you very much. I think we have plenty of time for questions and discussion, so I'll open it to the floor. Yep.
Hi. You mentioned the Italian case in 2015, where the court referred to a high rate of social approval, and that's why we should recognize same-sex couples' rights, which it's one of the reasons that the court in Hong Kong has been using to reject rights of LGBT couples in Hong Kong. So I was just wondering, as a former judge, what's your personal take on that, especially in the light of an expectation that the court should be a gatekeeper for especially minority rights in the face of, so to speak, tyranny of the majority. The court should stand up to defend those rights. So what's your opinion on that? Thanks.
I think I'm not in a position to give, of course, any advice to the Court of Final Appeals, which is, of course, a court of a very high standing and a very developed understanding of fundamental rights. What I can only say is that, number one, the Court of Final Appeals is very open to references to foreign law or decisions of courts, even not directly connected to the jurisdiction of the Court of Final Appeal. Professor Chen wrote once a very interesting article, just documented how the European Convention is used by the Court of Final Appeals. And cases like the W case, transsexual case, showed that if the Court of Final Appeals wanted to do it, it could take the existing case law from other jurisdictions to adopt a decision which was a decision changing the, let's say, existing situation in constitutional law and fundamental rights. So what I want to say is that, let's say, methodological premises are there. Some already established how to do it model is there. Well, if the courts of Hong Kong decide that it is time that such decision is now taken in respect to same-sex couples, it probably could easily use the same technique. Is it time for it? Again, this I don't think I am in a position to make any judgments. This has to be decided by Hong Kong courts according to their knowledge on situation in this part of the world.
Marco?
Thank you very much for a very wide-ranging and a very clear talk. I was wondering whether you could say a little bit about children. And when I say children, I'm thinking less about kind of adoption of children by gay and lesbian couples, but gay and lesbian children. So in the back of my mind, the case I'm thinking about is the case about the Russian gay propaganda law that restricted children's access to gay-related material. So, I mean, is children a category that looms large in the court's consideration of questions about sexual orientation, and not necessarily as rights bearers in and of themselves, but as a category that the court takes into consideration?
Well, I suppose it depends on the type and nature of cases. The Russian cases are mostly cases where there is a mixture of criminal sanction and limitations of freedom of expression. Generally speaking, of course, interests of children may justify limitations of freedom of expression. The way, of course, how it is used in both legislation and practice in Russia is, of course, unacceptable, and there were already some decisions of the European Court of Human Rights condemning this version of prohibition of so-called gay propaganda, or whatever we call it. So most probably some reasonable system of making children acquainted that there are different sexual orientations without necessarily to promote or to discourage children from any kind of, without making any particular value judgment. This is probably something necessary. This is something very complicated. And here again, the problem is to what extent we should defer to legislative solutions, to what extent we can expect courts to take some decisions by themselves. But what is interesting is also the way how those, let's say, children arguments are used. In discussions in Europe, particularly in discussions of the conservative side, one of the arguments against recognition of same-sex couple is, yeah, but the next step is adoption, and they will have access to children, and they will degenerate the minds of the children, and so on, and so on, and so on. So we cannot do it, because once we allow full legal recognition of same-sex couples, this would be catastrophic for children. Now, the US Supreme Court said exactly opposite in Obergefell. They said, well, and the fact is that there are numerous same-sex couples in the US having children in sense of raising children in their families. And it is working. So we have to recognize it. So they completely inverse the, let's say, argument and the conclusion, meaning, again, this is probably very much culturally oriented. This is not easy. I'm watching this myself, and of course in a very limited perspective as a grandfather, when I see how two young granddaughters, 4 and 6 years old, are acquainted in kindergarten exactly with these problems, which also is another side. They are also acquainted with problems of other types of discriminations. First of all, the race discrimination. It's challenging. It's not easy, and so I must say this is something which, of course, must be done. But how to do it? I do not have any receipt. To what extent it enters the area of fundamental rights? Of course it does. But to what extent it should be left to some kind of discretion of local governments, other authorities which are closer to particular society, maybe.
Other questions, comments? Yes.
Thank you very much for your talk. Just because you mentioned briefly the Canadian development as well as the South African development. My limited understanding is that within those two jurisdictions, dignity jurisprudence has played a very important role. I'm just wondering whether the right to dignity is part of that emergence of fundamental rights. Is that something that you may be able to characterize as?
It depends, because most constitutional Supreme Courts have their own, let's say, magic formula. If you do not know, or if you are not able to find any specific constitutional ground to decide, then you use or you refer to one of this general, or this magic formula. This may be human dignity, so Israel, Germany, Canada to some extent. This may be equality or prohibition of discrimination. France, for example, US to some extent. This may be due process. So there are different ways. So some courts are more talkative in including arguments based on human dignity. And this was very interesting that in the US case of Obergefell, human dignity was given even more recognition than equal protection, which was not exactly in line with the traditional approach of the US Supreme Court, and even Kennedy was criticized later for this. Again, for this judgment of the Supreme Court of Canada in 2004, the Supreme Court was in a relatively easy situation because they simply said the proposed legislation is not unconstitutional. So they did not need any very strong constitutional basis for their decision. There was rather indication that there is no unconstitutionality in what the courts want to do. But you're right. For Canadian Supreme Court, human dignity plays probably more visible role, but not as visible as for the South African court. South African court has always been influenced by the German case law, at least to some extent. And this was probably one of the examples. 2005, it's already well-developed case law. On the other hand, the South African decision was written by Justice Sachs, Albie Sachs, and he's a very he used to be a very activistic judge. So of course his arguments were more oriented toward general values than probably would have been arguments of other judges had they got the task to draft the decision. But again, I think that human dignity as an argument is visible in almost all judgments of the courts. Sometimes it is elevated to one of the most articulated and most important arguments. Sometimes it is rather regarded as some kind of a value basis which is obvious but which need not be addressed in a particularly elaborated manner. But this rather depends on the style of judicial decision and general role of human dignity as constitutional argument. Also for the European Court of Human Rights, human dignity is used, but not, let's say, in an excessive manner.
Other questions? I have a lot of questions, actually. I've been holding off to give you a chance. You talked about this pattern and the predominant pattern in Europe of starting with the legislature and then the challenges before the courts. In other places, it's gone the other way. How do you explain that in the European context? Can you explain that that pattern in the European context in particular?
Well, I would say not all European courts, or rather not all constitutional Supreme Courts in Europe are, generally speaking, very active. So the strongest courts, like the German court or the Spanish court, they simply waited to be invited. I think that in those leading West European countries, decisions concerning recognition, or legal recognition of same-sex couples were taken in a relatively fast pace. So before the courts could be ready to intervene, there was already legislation, and this legislation was, let's say, a decent one, or not provoking any, let's say, particular constitutional conflicts or challenges. As we can see, except in case of South Africa, those other important judicial decisions were taken later. Were taken only when there was already clear that there is some kind of universal trend of recognition. And it's probably not by accident that the US Supreme Court has waited a long time, and they took this decision practically 10, maybe 15 years after similar problems has already been successfully dealt with in several European countries. But they declared there is a fundamental right, and this is, of course, also very important.
What do you think it will take, or at what point might the European Court of Human Rights position shift? I mean, when you talk about the trends that are shaping some of these other or the decisions in these other jurisdictions, do you think at what point would there be a consensus that would be sufficient for the European Court to finally articulate a fundamental right?
This is difficult to tell, because there is now there are some signs, let's say, of petrification of the positions. Those countries who did not decide to provide legal recognition within last, let's say, 10 years or something, are still declaring that it is not possible. And these are several countries, and this is probably should be seen upon this new populistic trends in many countries, also in European countries. So countries like Russia or Hungary or Ukraine, unfortunately also Poland, are countries who clearly declare we are not going to do it. Whether the European Court should try to impose, probably would it be followed? In my opinion, not in Russia. But the question is how long one can pretend that Russia is in the system if Russia is not following the basis requirements of that system. Other countries, maybe yes, maybe not. At least it would not make any harm for these countries. Whether the European Court is ready to do it, I'm not sure. The European Court is now more careful, is more under attack. Remember that it is not attacked only by Russia, but also by the United Kingdom, which is extremely anti-productive, is now composed of less, let's say, activistic judges. Finally, judges are nominated by member countries. So I'm not very optimistic that something would happen immediately, but who knows? Miracles happen.
We have time for one more question, if anybody. It's Friday night. And some of my students are here. We do have class after this session on a Friday evening, so you can feel sorry for us. Well, thank you very much. You said brief at one point, but actually that was an extremely comprehensive and very rich overview of supranational approaches, European approaches, but even beyond Europe, to sexual orientation issues, and particularly legal recognition of same-sex relationships. I think it's helped us to make some sense of this very complex, dynamic situation. And still, you did give us a lot of clues about what the road ahead might look like in these various contexts. And I greatly appreciate sharing all of your knowledge with us. Thank you.
Thank you. Thank you. It was a pleasure.